My name is Jocelyn Katz, and I'm the head of the competition department at ENSafrica, Africa's largest law firm. In this video, I'll be speaking to you about some novel developments taking place both internationally and locally here in South Africa. In short, I'll be addressing the intersection between competition law and data protection laws, specifically in relation to digital markets and the various issues that arise. I'll begin with a brief contextual overview of where these debates come from and the rise of data protection laws and how these interact with competition law. I'll then distinguish between where data protection laws constitute an element of competition and where data protection laws can serve as an external constraint on the application of competition law by imposing limits on what would otherwise be permissible from a competition law perspective. This will involve an examination of the important role of data and the potential dangers that such data can pose in the hands of big data firms. I'll examine the problems posed by mergers in the digital economy, which will entail looking at whether data protection laws can serve to limit merger activity and some key issues to be aware of when contemplating mergers in the digital economy, as well as some possible solutions to address these problems. Finally, I'll address how data has drastically changed how cartels operate and how competition authorities will need to adapt to these novel developments. Of course, there is also an entire discussion on the role of data in establishing and entrenching dominance and the abuses that can arise, but that probably constitutes a topic all of its own, so I will not go into it here. I will primarily be speaking from a South African perspective, but the issues and principles that I will cover are of international application. So allow me to start by saying that I'm not a data protection lawyer. However, as digital markets and platforms are expected to continue to dominate the antitrust debate for years to come, the intersection between competition law and data protection laws has become an increasingly important topic that's being recognized by many competition authorities. As authorities around the world increase their focus on the use of data, AI, and algorithms, discussions as to whether existing antitrust toolkits are sufficient to deal with issues raised by the digital economy or whether radical reworking or new alternatives are needed is likely to intensify. Here in South Africa, the South African Competition Commission, which I'll usually refer to as the Commission going forward, has recently published a paper entitled Competition in the Digital Economy for public comment. Now, this digital economy paper, in line with international trends and similar papers issued by other competition regulators, really sets out the Commission's approach and proposed solutions to the issues raised by the digital economy in the South African competition sphere. By way of background, it's important for us to understand the role and origin of data protection laws before we can assess how these interact with competition laws and the competition issues raised by the digital economy. As you'll all know, in 2018, the EU's GDPR, General Data Protection Regulation, came into effect. This has had a profound effect as many African firms and businesses here either have offices in the EU, process data in the EU, or do business in the EU or with EU member states. As the EU Commission grapples with the interplay between data protection laws and competition laws, we note that these issues are likely to permeate into Africa, as so far 24 out of possible 56 African countries have adopted laws and regulations to protect personal data, most of them based on the GDPR, as well as its predecessor, the EU Directive on Data Protection. South Africa's Protection of Personal Information Act, which is also referred to as POPIA, came into force in July this year. Now, POPIA prescribes 8 conditions for the lawful processing of personal information, which are cumulative, apply horizontally, and broadly accord with the principles found in the GDPR and EU Directive. There are some important differences, though, such as the fact that unlike the GDPR, POPIA also applies to juristic person data subjects. So it will be interesting to see how the competition authorities and the newly established information regulator deal with the interplay between POPIA and competition law moving forward. As I mentioned earlier, I'll be speaking mostly from a South African standpoint. However, given that we and many other African jurisdictions have based our data protection laws on the GDPR or the EU Directive, as the case may be, many of the issues and proposed solutions that I'll address should apply equally to other jurisdictions. So competition, data protection, and consumer laws serve similar but also very different goals insofar as they all seek to advance the interests of consumers and consumer welfare in some way. So while there's a material overlap, there are also many areas of divergence where the constituent components of these other areas of law are fulfilled, then their application to a given scenario remains appropriate. However, This could lead to differing results when assessed by differing regulators under different laws. The intersection between competition law and data protection law therefore becomes a focal point. It will become increasingly important for competition authorities to liaise and coordinate with their data protection counterparts in order to avoid any turf wars. The South African Competition Act provides that if there is concurrent jurisdiction between the Commission and other regulatory authorities, then a cooperation agreement must be entered into between these two authorities. POPIA also provides where the information regulator considers that a complaint relates either wholly or partly to a matter that is regulated in terms of another law, then it must refer the matter to the relevant regulatory authority to be dealt with accordingly. The Commission has noted the need for such collaboration in its digital economy paper. However, as digitalization continues to rise and privacy issues take center stage, competition lawyers around the world have expressed concern that competition law could be co-opted to achieve non-competition aims. As proposed by the London School of Economics, it therefore becomes important to distinguish between where data protection acts as an internal influence on competition law and where it acts as an external influence. So data protection would constitute an internal influence where it's considered as a competitive parameter. In other words, where there's competition on data and the levels of data protection offered. In these cases, competition law internalizes data protection assessments, which are taken into account as an element of consumer welfare by competition authorities. The South African Commission is already well equipped to deal with these conventional competition violations involving data, for instance, where there's an agreement between competitors not to share certain forms of data or not to compete on the level of data protection offered to their users. It's in the analysis of the anti-competitive effects of such restrictive horizontal agreements that could be quite complex. However, this is another area where we can learn from the EU, which has developed more experience in this regard. The Digital Economy paper also notes the need to rethink theories of harm and potentially rely on data experts in order to prove anti-competitive effects, as this can get quite technical. On the other hand, data protection law could act as an external influence insofar as it could serve as a binding limit on competition law enforcement. Now, for example, where data protection laws prevent a competition authority from accepting a commitment or imposing a remedy that it would otherwise consider appropriate or desirable. So, by way of example, ordering access to data as an essential facility or accepting an obligation that data will be shared with emerging entities' competitors in order to lower barriers to entry, particularly in markets where big data firms act as gatekeepers. Big data firms have increasingly been center stage, with companies such as Facebook, Apple, Amazon, and Google coming under increased global scrutiny, including in the US, the EU, and Australia. Recently, the United States Department of Justice filed an antitrust suit against Google, the most significant monopoly-related charges to be filed in the US since the case against Microsoft in 1998. Although these firms are not all being targeted for the exact same transgressions, a common complaint against them relates to how they handle, process, and share their users' data and what this data is ultimately used for. The problem with many digital markets is that entrants into these respective markets are at a seemingly insurmountable disadvantage due to the vast cache of data already held by their competitors, the big data firms, who are able to offer consumers a seamless service by sharing their data across multiple platforms. So, in order to mitigate this, competition authorities may seek to lower the high barriers to entry faced by new market entrants by ordering access to information held by these data companies, where such data may be necessary to allow potential new entrants to become effective competitors, or where the data constitutes an essential facility. However, data protection laws could potentially prevent this, especially in digital markets where the information held by these big data firms actually belongs to the consumer. Accordingly, distinctions between data belonging to the companies and data belonging to consumers would be necessary, particularly given that in a South African context, POPIA applies to juristic persons as well as natural persons. Such data sharing would need to comply with the conditions for lawful processing under POPIA, which include the processing limitation, which is consent, justification, and the collection of personal information directly from the data subject, as well as the purpose specification conditions, that is, data collected must be for specific purpose. The further processing limitation, that is, that data may not be processed further for a purpose other than that for which it was originally acquired or processed, and openness. In short, consumers must be aware of what is happening with their data and potentially be given the opportunity to object to such data sharing. The easiest condition for lawful processing would be to obtain the data subject's consent. However, personal information may be processed without consent where it's necessary for pursuing the legitimate interests of the responsible party or of a third party to whom the information is supplied. Another lawful condition for processing is that any further processing of personal information must be compatible with a reason for collection. So, notably, these legitimate interest justifications do not apply to further processing, which must always be compatible with the purpose of collection. So, when viewed from a data protection perspective, the conditions for the lawful processing of personal information may form a bar against competition authorities ordering access to data by actual or potential competitors, irrespective of whether they are ordering such access as access to an essential facility or accepting an undertaking from a party that it will share its data with its competitors, for example, in the context of a merger. Another related and prevalent issue is that of big data firms buying up their smaller competitors before they've had a chance to become a threat. These are so-called killer acquisitions. Because if smaller entrants cannot compete, they are likely to sell. This has been exacerbated by the fact that many such mergers are not notifiable, as they fall below the monetary thresholds given the lack of actual monetary turnover, despite the fact that the innovations developed by the small target firms could potentially impact in the hands of a big data firm. So, competition authorities will likely seek to find a way to ascribe a monetary value to data, which is considered the new oil or the money of the modern age, as many digital markets require their users' data in lieu of actual currency. Indeed, Germany has effected legislative changes in order to properly monetize the access to customer data, triggering merger filing requirements. Linked to this is the actual assessment of competition issues, since there may be no horizontal overlap between the acquiring firm, in this case the big data firm, and the target firm, and yet forms of data that would otherwise not be available to the acquirer, which could potentially provide insight into behavior, thinking, and preferences of individuals or customers, is obtained by the acquisition of the target, offering the acquirer a greater competitive advantage. Such mergers are ordinarily approved on the basis that there is insufficient evidence of a substantial loss in prevention of competition in the market, without necessarily assessing these unquantifiable gains that could impact competition. It may therefore be necessary to consider data as an element of market power in digital markets, as even a seemingly small acquisition could significantly enhance a firm's competitive position. Vertical mergers can also pose problems, as vertically integrated digital firms can benefit from owning a platform and at the same time competing with sellers on that platform, which incentivizes self-preferencing, an act by which digital platforms will give preferential treatment to their services over the services of other companies. So regulators will likely seek to solve for this by introducing changes like making all mergers involving digital markets notifiable and introducing a rebuttable presumption that these mergers will lead to a substantial lessening of prevention of competition, placing a reverse onus on the merging parties to show otherwise. However, what will be critical is to balance these competition concerns against the dampening of innovation. Care must be taken not to make the regulatory framework so onerous so as to discourage mergers in this sphere, as many startup companies develop their products in the hopes that they'll be acquired by a big data firm. In South Africa, the digital economy paper seems to adopt a kind of middle-of-the-road approach by suggesting that all mergers involving specified dominant tech firms be made notifiable, and that a guidance note clarifying the valuation of assets for non-specified digital companies be issued, as well as a practice note on merger creep and digital market merger assessment. A further recommendation made by the digital economy paper is that domestically notifiable tech mergers are concurrently filed in South Africa and other major jurisdictions, such that the Commission benefits from collaboration with other competition regulators in the assessment of the merger. Such international collaboration is likely to be an increasing trend moving forward, not just here in South Africa, but globally, since digital markets are not constrained by geographical borders. Data protection laws are also important in the context of international mergers, as POPIA restricts trans-border information flows, providing that personal information about a data subject, which could be a natural or juristic person, may not be transferred to a third party in a foreign country unless certain safeguards are met. These safeguards include the third party being subject to a comparable data protection law or a binding agreement or binding corporate rules in respect of transfers within a group of companies that offer a similar level of protection to POPIA and that also have similar restrictions on cross-border data flows. This could potentially have an impact for multi-jurisdictional mergers where one of the affected countries has no data protection laws, in which case a binding agreement or another safeguard would be necessary. In the context of juristic person personal information, the adequacy of a foreign data protection law also cannot be relied on, since other jurisdictions do not extend data protection laws to juristic persons. POPIA does provide, however, that transborder data transfers are permissible where the data subject consents to the transfer, or where the transfer is necessary for the conclusion or performance of a contract concluded between the data subject and the responsible party, or where such contract is concluded between the responsible party and a third party in the interests of the data subject. Moreover, whether data protection laws can impose prior restraints on a data-driven merger is an open query, leading to the ongoing discussion about whether the impact of such transactions on data protection and privacy should be considered before the transaction is approved by competition authorities. For example, POPIA requires a responsible party to obtain prior authorization from the regulator if it intends to process any unique identifiers of data subjects for another purpose than intended at collection, and with the aim of linking the information with information processed by other responsible parties. In this instance, a unique identifier can be any identifier that uniquely identifies a data subject in relation to the responsible party, such as, for example, an identity number or an employee number. There are heavy penalties for non-compliance with this section. So it's easy to see how this could potentially pose a problem for merger control, especially when acquiring firm wishes to acquire a target for the data it possesses, as a consumer may have consented to giving their information to the target firm, but take issue with it being processed by the acquiring firm. This problem is compounded further in the South African context when one considers that, unlike the GDPR, POPIA applies not just to natural persons but also to juristic persons. So differing between data belonging to the juristic person and data belonging to its customers is essential in terms of the basis on which the respective data transfers would be lawful. The primacy of data protection laws may also pose a problem, as depending on the jurisdiction, these laws may prevail over the competition laws. For example, POPIA establishes the principle that whatever legislation provision provides the most protection to data subjects will prevail. So where any provision of any other legislation that regulates the processing of personal information is materially inconsistent with an object or a specific provision of POPIA, POPIA will apply to the exclusion of that provision. It's unclear whether this could include the processing of data and sharing information necessary to effect a merger or establish a joint venture, a matter that would necessarily contravene the Competition Act, but that would not necessarily contravene the Competition Act, but may fall foul of data protection laws. What is clear, however, is that it would be contrary to business efficacy if data protection laws could be used to stifle merger activity. While legislation may provide for the respective regulators to refer matters to it that fall within another regulator's jurisdiction to that regulator, as POPIA does, as noted earlier, given the areas of convergence in their respective competencies, cooperation between the authorities is necessary. Absent such cooperation, even if the competition authorities were to approve a merger subject to the condition of approval of the data transfer by the regulator, or on the basis that the merging parties can only share information to the extent permissible by data protection laws, it would still be contrary to business efficacy insofar as there would be further expensive and time-consuming regulatory hurdles for merging parties to jump through. It would be preferable for the authorities to engage with each other on the approach to be followed and develop a unified approach. These problems may, however, turn out to be somewhat more academic than practical. However, because consent is not always required for data processing. In South Africa, POPIA provides that personal information may be processed where such processing is necessary for the proper performance of a public law duty by a public body, so for instance the competition authorities, or where such processing is necessary for pursuing the legitimate interests of the responsible party or of a third party to whom the information is supplied. Although this limitation or exemption doesn't apply if the data is further processed for a purpose other than that for which it was originally acquired. Acquiring firms should also be wary of the risks and liability that they are acquiring from a data protection perspective, as they may end up liable for data protection violations committed by the target firm, as recently illustrated by the case against the Marriott International Hotel Group under the GDPR. In a nutshell, Marriott International acquired a rival company, Starwood Hotels, whose guest reservation database was compromised. However, because Marriott failed to conduct a proper due diligence upon acquiring Starwood, this compromise went undetected for some time, resulting in approximately 339 million guest records globally containing a variety of important personal data being exposed by the incident. The UK Information Commissioner's Office has fined Marriott a fairly significant £18.4 million for its breaches of data protection law, stating that the GDPR makes it clear that organisations must be accountable for the personal data they hold. This can include carrying out proper due diligence when making a corporate acquisition and putting in place proper accountability measures to assess not only what personal data has been acquired, but also how it is protected. This case serves as a sobering reminder to be cognizant of data protection laws when making acquisitions, and certainly this is something that we're going to need to look out for in the South African market going forward. Leaving aside the arena of merger control for a moment, data sharing poses risks in other areas of competition law. As I mentioned earlier, I think we are all aware that information sharing between competitors could constitute a horizontal or vertical restrictive practice, although depending on the data shared, the analysis of its potential anti-competitive effects could often be quite complex. Similarly, where data protection law acts as an internal influence on competition law, and there's competition on either the amount of data acquired from the level of data protection offered to a consumer, an agreement between competitors not to compete in these regards would also be prohibited. Digitalization has also radically changed the ways in which cartels can operate, as developments in digital markets have changed market conditions and how market players behave and compete with one another, and has created new methods of collusion. A challenge is that traditional methods of detection of collusion may not be suitable in digital markets, requiring competition regulators to explore new methods of detection. For example, cartelists could develop and share algorithms that allow competing firms to simultaneously adjust prices based on the inflow of market data, or algorithms that lead to price setting, market allocation, or collusive tendering. Similarly, cartelists could use data to set prices amongst competitors and use data analytics to monitor pricing agreements amongst competing firms, thereby using data to facilitate tacit collusion, for instance, by programming collective retaliation to price changes in a market. To address these issues, the Digital Economy paper proposes the development of appropriate tools for detecting digital cartels and assessing the effects of these agreements amongst competitors, piloting a tender bid rigging detection program that aims to use public sector tender data to develop an automated cartel detection tool, building and staffing a cartels forensics lab that will provide the computing infrastructure for large-scale data analysis, and scrapping price data from the internet. And finally, the development of guidelines for establishing the Commission's jurisdiction in cases of digital collusion that have an effect in South Africa. Ultimately, digitalization has combined many things that were previously regulated by separate regulatory regimes, prompting the need for collaboration between competition and data protection authorities, both locally and internationally, as digital markets are not constrained by geography. Cooperation between competition authorities and data protection authorities is also critical to avoid turf wars or differing results under the different laws. As noted by the Irish Data Protection Commissioner in her annual report for 2017, coherence between data protection, competition and consumer law is necessary to deliver a fair deal to service users, as one hand cannot approve a merger without conditions, while the other hand effectively has to try and block it after the fact by preventing data sharing between the two. This stage of development of the intersection between data protection law and competition law, with a flavour of consumer law, has been dubbed the dawn of the Uber protection. From a South African perspective, there are many lessons to be learned from foreign and international laws as to how to navigate this dawn of Uber protection. However, as noted by the President of the South African Competition Appeal Court, Judge Dennis Davis, countries need to adapt what they are borrowing for their own indigenous developmental needs. We will continue to monitor these issues as they evolve in an African context. Thanks very much.